The final thing I'd like to talk about is what happens when things go horribly wrong. If you or the other side does not comply with the discovery rules, you may be penalized, or the other side may be penalized by a motion filed by the aggrieved party. The type of motion you file and the penalty that could be requested depends upon the type of discovery that has been asked. The first problem you might run into is that you send out a discovery request and there is no response. If this is a request for admissions, it will be handled a little bit differently than the other types of discovery. In the case of a request for admissions, your remedy is to file a motion to deem admissions as admitted. This is asking the court to rule that each of the facts that you ask the other side to admit or documents that you ask them to admit are genuine be deemed to be true or genuine because the other side failed to deny them. This type of motion can potentially lead to devastating results to the other side if they do not serve responses to the requests for admissions by the date of the motion. Although the court generally prefers a meet and confer letter to be sent out prior to filing this type of motion, it is not required by the statute or the court before the court can grant orders or issue sanctions. Because this type of motion carries with it mandatory attorney fee sanctions, this has created a system in which some attorneys are incredibly anxious to file this type of motion the moment that a self-represented litigant fails to serve responses to a request for admissions, because these attorney's fees will be awarded even if a response to the request for admissions is served prior to the date of the motion. If the response is served prior to the date of the motion, although the facts will not be deemed true, this mandatory awarding of attorney's fees has made this a particularly popular motion against self-represented litigants by attorneys. The unfair thing about this is, as a self-represented litigant, the Sacramento court interprets attorney fee sanctions very strictly and cannot award these sanctions to you since you do not have any attorney's fees. If you do file this type of motion, you will be able to claim your motion fees, the $60 you pay to file your motion. However, you will not even be able to claim this if your fees are waived. If, on the other hand, the type of discovery that was served out was a form or special interrogatories or request for production, the court will require a meet and confer letter and will not award sanctions generally in the absence of such a meet and confer letter, and may even penalize the side making the motion if they do not make reasonable attempts to resolve the dispute first. The type of motion that would be filed would be a motion to compel responses. This is asking the court to order the other side to respond without objection. If it's granted, the court will usually set a specific date for the other side to respond, oftentimes around 20 days, and order that these responses be without objections. Sanctions are often not awarded if this type of motion is not opposed, and sanctions cannot be awarded unless there is a meet and confer attempt by the side making the motion. The second problem you might run into is that you receive responses, however they're incomplete, or contain a bunch of legal objections without merit and no factual answers. In this case, the court will require a meet and confer letter before filing the motion, giving the other side an opportunity to resolve the dispute. In this case, the meet and confer letter should explain the inadequacy of the responses and ask that additional responses be provided identifying the specific discovery requests that are being asked to be responded to. If this does not resolve the dispute, the remedy is to file a motion to compel further responses. The party requesting this may ask the court for an order directing these further responses. The motion itself must identify in a separate statement the specific discovery request that was made, the response that was made to it, and the specific reasons why a further response is required. This motion must also be filed within 45 days of the inadequate responses being served. However, if they were served by mail, additional time is provided. So, if served by mail within California, for example, the motion must be filed within 50 days of the responses being served by mail. Failure to file this motion within the deadline is an acceptance of the responses that were given and waives any opportunity to demand further responses from the other side. Let's say that you've already received an order compelling responses or ordering further responses, yet the other side has not responded or continues to, after several repeated attempts, make inadequate responses. Your next step would be to file a motion for sanctions. A sanction is a penalty ordered by the court. Generally, a meet and confer letter is not required for this type of motion because by the time this motion is made, the other side has demonstrated that they are not willing to comply with the court's previous orders, so another meet and confer letter would generally be deemed fruitless. The type of sanctions that the court may issue range anywhere from terminating sanctions, which is the most extreme, to monetary sanctions or issue sanctions in between the two. Terminating sanctions are reserved for the most extreme cases. These are issued where the opposing party has abused the discovery process and has done so in a way that dismissing their case if they're the plaintiff or striking their answer if they're the defendant is an appropriate remedy for the abuse. Remember that the penalty imposed by the court cannot place the requesting party in any position better than he or she would have been had the sanctioned party responded, but in a way most favorable to the requesting party. A good example of terminating sanctions came through our doors a number of years ago. In this case, a person was being sued on an extremely old debt that was most likely over the statute of limitations. She didn't recognize the creditor or the plaintiff and had absolutely no idea where the alleged debt came from, as it did not appear on her credit report. So, she served a single request for production, and it read something like, "Produce any document of your choosing that evidences in any way that the defendant owes the plaintiff as alleged in the complaint." In response to this, she received nothing other than a 2-page long objection to the request for production. She filed a motion to compel a further response after meeting and conferring, and the opposing party opposed the motion on the ground that the request was vague and ambiguous and any number of other objections that they had previously raised. At hearing, the court determined that although it was true that the request could have been better written, it was reasonably clear what was being asked. She was asking that the plaintiff produce any one document of his choosing showing that she owed him anything. That was it. Under these circumstances, the court ordered that the plaintiff comply with the request and produce any one document of his choosing that evidenced that she owed him anything as alleged in the complaint. He subsequently just re-raised his objections and failed to provide any further response. So, after receiving this non-response, she filed a motion for terminating sanctions. And her motion was based on the idea that she had only requested a single thing, that a single document be produced that evidenced in any way that she owed the plaintiff anything, and that his failure to produce this evidence meant that he had none, and therefore the case should be dismissed. The plaintiff then failed to respond to this motion, and the court granted the dismissal of the case, reasoning that if he had any evidence, he could have produced it, and his failure to oppose the motion was a concession that he had no such evidence. This is terminating sanctions, the most extreme sanction that is available in discovery. The second type of discovery sanction that you might encounter are issue sanctions. Issue sanctions are sanctions in which the court orders that a particular issue is resolved and either is decided in a certain way or cannot be produced at trial. A good example of this happened a number of years ago when a woman was injured by a piece that had fallen off of a ride. When it responded, one of the defenses that the carnival operator had raised was that the ride suffered from a manufacturer's defect, and therefore it was not responsible, but the manufacturer was. During the course of discovery, the plaintiff asked to examine the bolt that had snapped on the ride. The idea was that this bolt would be x-rayed to determine whether or not the bolt was defective in its manufacture, or whether the bolt had been broken from being attached. This would have allowed the issue of the manufacturer's defect to be resolved. Unfortunately, the response that the plaintiff received back from the defendant was that the piece had been thrown out. The plaintiff then filed a motion for issue sanctions, and the sanction that was requested and the one that was granted is that although the defendant could raise any other defense, it was no longer able to raise the defense that it was a manufacturer's defect. This placed the plaintiff in the position that she would have been in had the defendant replied, but in a way most favorable to her. That's an issue sanction. Finally, monetary sanctions are given by the court in cases where the discovery process has been abused. However, it is not appropriate to grant issue sanctions or terminating sanctions. If the amount of discovery that is served is excessive, the party that is responding can object to the discovery or seek a protective order against it. In a limited case, where discovery is limited to 35 combined form interrogatories, special interrogatories, requests for production, or requests for admissions, as long as the responding party objects within the 30 or 35 days that is permitted to respond, that party may object to any discovery over the 35, on the ground that the discovery exceeds the amount permitted under Code of Civil Procedure Section 94. In the event of an unlimited case, however, if the parties are unable to informally resolve the issue through the meet and confer process, the party that is subjected to abusive discovery would need to go to the court to file a motion for a protective order. This motion must be filed within the time limit to respond to the discovery, or the objection to the amount of discovery is waived. If the motion is granted, then the discovery would be limited by the court. There are certainly many other issues that will occur during the discovery process. However, this presentation is too short to go into all of them. For this reason, you may benefit from other resources that are available in the library. First, especially if your lawsuit is a limited civil case, you might read Win Your Lawsuit by Nolo Press. Chapter 10 in this book deals specifically with discovery. The primary difference between discovery in a limited case is that you are permitted more discovery in an unlimited case. So, even though this book deals with handling a limited civil lawsuit, much of the information provided will still be useful. Another book you may find useful is California Practice Guide Civil Procedure Before Trial by the Rudder Group. Its call number is listed in the slide. This book, and several other practice guides that the reference librarian may be able to recommend, looks intimidating on the shelf, but when you actually open up the book, it contains a number of tabs with titles such as Creating Your Discovery Plan, Depositions, Interrogatories, and things like that that allow you to quickly find the chapter you are looking for. Each of these chapters begins with a table of contents, which allows you to quickly find the information that you want within it, and the chapter itself is relatively short, typically around 20 or 30 pages. The target audience for this book is attorneys and paralegals, even if they don't have any experience in litigating a civil case. So although there is some learning curve to using this resource, it is not insurmountable. I would highly recommend taking a look at this book, as there are very few questions of civil procedure that you can't readily find the answer to in a fairly short amount of time by using it. The other two books on the list are CEB Action Guides. These are by the Continuing Education for the Bar, and they are dark blue books about 100 pages in length. These books tend to provide very practical, wheels meets the road, step-by-step instructions on procedures that you might deal with in the court. These books have a bit of a steeper learning curve than the other practice guides, but are very straightforward in handling things step by step. Some people absolutely swear by them. I would not hesitate to look at them. The one, Obtaining Discovery, Initiating and Responding to Discovery Procedures, is more or less the information that was provided here in this program, but with some additional detail, and the guide, Creating Your Discovery Plan, tends to deal more with strategy. I hope that you have enjoyed this presentation and encourage you to begin your discovery process in your case as early as possible. Good luck.